Welcome to Sunny's Mindset Lab podcast. Today, we're exploring protecting your number one asset with its author, Michael A. Lecter. This book explains why ideas are often our most valuable assets and how failing to protect them can destroy long-term value. Michael, welcome to the show.
Thank you, Sunny. Protecting your number one asset was written to help creators, entrepreneurs, and professionals understand how intellectual property works and how to safeguard the ideas that drive success.
I'm so glad you're here to walk us through it. For our listeners, I'd love to structure our conversation around the key pillars of your book. We'll start with that core concept of ideas being our number one asset. Then we can unpack what you call the intellectual property toolkit, patents, trademarks, copyrights, and trade secrets. And finally, we'll wrap up with the crucial topics of strategy and ownership. Does that sound good?
That's a perfect roadmap. Let's get into it.
Great. So, Michael, let's start with the title itself. In a world that's so focused on tangible things like real estate or investments, you make a pretty bold claim, one that's echoed by Robert Kiyosaki in his foreword to your book, that our mind and the ideas it produces are our true number one asset. Why do you frame it that way? Well, it's really a reflection of the economy we live in today. We've moved from an industrial economy to an information economy. Physical assets, they're finite. But as I point out in the book, imagination is infinite. The real challenge, though, is that while it's very difficult for someone to steal your house without you noticing, an idea can be taken in an instant. If it's not protected, that idea goes from being your greatest potential asset to a massive liability. An unprotected idea as a liability, that's a powerful and frankly a scary thought. To make this real for people, your book starts with a few horror stories. Can you share one of those with us? I was particularly struck by the story of the inventor, let's call him Ackman, and his groundbreaking video game. He thought he had a huge hit, but it ended in disaster. What exactly went wrong?
Ackman's story is a textbook example of using the wrong tool for the job. He wasn't completely negligent. He did take a step to protect his work by getting a copyright for his software. But here's the critical distinction he missed. A copyright only protects the form of expression. In his case, that meant the specific lines of code he wrote and the specific graphics he created. It did not protect the underlying idea, the game mechanics, or the way the game functioned. So competitors came along, legally copied the concept of his game, wrote their own code, and designed their own art, and launched functionally identical products. His copyright was completely useless to stop them.
Wow. So he protected the painting, but not the idea of what the painting depicted. That story is the perfect segue into the next topic then. It shows that just getting protection isn't enough. You need the right kind of protection. In the book, you lay out what you call the intellectual property toolkit. Could you give us an overview of the four main tools in that kit? Of course. There are four primary tools, and each serves a very different purpose. First, you have patents. These are designed to protect inventions and ideas themselves, granting you what is essentially a legal monopoly for a limited time. This is the tool Ackman needed for his game mechanics. Second are trademarks, which protect your brand identity, your names, your logos, anything that signifies the source of goods or services. Third, as we just discussed, are copyrights, which protect the specific expression of an idea, not the idea itself. Think of the words in a book, the music in a song, or the code in a program. And finally, you have trade secrets. This protects confidential information that gives you a competitive edge, like the Coca-Cola formula. Its protection lasts as long as you can keep it a secret. That's a fantastic breakdown. Let's dig into that first one, patents, a little deeper. You describe it as the strongest form of protection, even a legal monopoly. That sounds incredibly valuable. So when should an inventor or an entrepreneur be thinking, okay, this is something I need a patent for? A patent is for a genuine invention, a new and non-obvious process, machine, or composition of matter. And what's absolutely crucial to understand is that it's the only tool in the toolkit that protects the underlying idea or functionality itself. To bring it back to Ackman's story, a patent on his unique game mechanics could have stopped his competitors cold, even if they wrote completely different code. It grants the owner the exclusive right to make, use, and sell that invention for a set period. Now, I've definitely heard entrepreneurs, especially in the startup world, talk about getting a provisional patent as a sort of quick and cheap first step to get protection. Your book has a pretty strong warning about this. Can you clarify that for us? I'm glad you brought that up, because it's one of the most common and dangerous myths in the world of IP. Let me be very clear. There is no such thing as a provisional patent. What actually exists is a provisional patent application. It's a critical distinction. The application is simply a one-year placeholder that locks in your filing date. It grants you zero enforceable rights on its own. If you don't follow up with a full, non-provisional application within that one-year window, it simply vanishes as if it never existed. Calling it a patent gives a false sense of security that can lead to disastrous consequences. So that one-year window is absolute. And speaking of timing, you also warn about the dangers of delaying your filing, particularly for anyone with global aspirations. What's the major difference between the rules in the US and in most other countries? This is another huge trap for unwary inventors. In the United States, you generally have a one-year grace period from the time you first publicly disclose your invention, say at a trade show or in an article, to file your patent application. But, and this is a big but, most other countries operate under what's called an absolute novelty rule. That means if you sell a single unit, give a public speech about it, or publish anything describing the invention before you have a patent application on file, you can be permanently barred from getting a patent in those countries. The protection is lost forever. That's a critical warning. Okay, so let's shift gears. A patent protects the function of an invention, but how do you protect its name, its logo, its identity in the marketplace? This brings us to the next tool in your kit, trademarks. How do they work? To protect what you call a company's reputation. A trademark, at its core, is a source identifier. It's the symbol, name, or slogan that tells a consumer this product comes from this specific company. It's the carrier of a company's reputation and goodwill, and failing to manage it can be incredibly costly. Another horror story in the book involves a company I call Z Corp. They invested a fortune developing a new product with a very catchy name, but they failed to do a simple trademark search. Right before their big launch, they received a cease and desist letter from another company that had already filed for an identical mark. Their entire marketing investment was suddenly at risk.
That highlights the importance of due diligence. But you also talk about a more subtle kind of damage, particularly from counterfeit goods. Many people might think, well, the person buying a $5 fake Rolex knows it's not real, so what's the harm? But you explain a legal concept called post-sale confusion. Can you break that down for us?
Certainly. This is where the real damage to a brand's reputation occurs. You're right, the initial buyer of the counterfeit isn't confused, but what happens next? They wear the watch, and maybe it breaks or begins to turn their wrist green. A friend, a neighbor, a colleague, a potential future customer for the real Rolex sees this and thinks, wow, Rolex quality has really gone downhill. In that moment, Rolex's reputation is tarnished in the eyes of someone who never even touched the fake product. Trademark law exists to prevent this kind of damage to a brand's goodwill in the entire marketplace, not just at the initial point of sale.
Fascinating. It's about protecting the perception of the brand for everyone. So let's move to our final two tools, copyrights and trade secrets. We've talked about the famous Coca-Cola formula as a trade secret. How is that fundamentally different from, for example, a copyrighted recipe you might find in a cookbook? They're essentially polar opposites in their approach. A copyright is designed to protect a public expression of an idea. For the cookbook, copyright protects the specific words and photos on the page. Someone else can legally use your recipe to bake a cake, and they can even write their own description of how to do it. A trade secret, on the other hand, derives its value and its legal protection entirely from being kept confidential. The protection for the Coca-Cola formula only exists as long as the company takes reasonable measures to keep it a secret. If that formula were to leak, the trade secret protection would be lost forever. So maintaining secrecy is absolutely everything for a trade secret. You have a case study in the book about a software company, TSI, that learned this the hard way. What was the mistake they made? TSI's mistake was assuming their software code was automatically a trade secret. They distributed their software widely to distributors and customers, but they failed to use any confidentiality or non-disclosure agreements. By doing this, they essentially published the code into the world, and as the court in that case effectively found, trade secret protection is simply not applicable to published material. Because they failed to take steps to maintain secrecy, a distributor was legally free to analyze the software and create a competing product. They gave away their most valuable asset without realizing it.
That case really highlights the limits of both trade, secret, and copyright protection for software. On that note, you describe a very clever and legal workaround that competitors use to replicate software functionality without infringing a copyright. It's called the clean room defense. How does that work? The clean room approach is a direct response to the fact that copyright protects expression, not function. A competitor will set up two completely isolated teams. Team 1 is allowed to look at the original software. They analyze it, figure out what it does, and then write a purely functional specification document. This document describes the features and behavior of the program, but it contains absolutely no original code. That spec is then handed to Team 2, the clean team, which has never seen the original program. They use only that functional spec to build a brand new piece of software from scratch. The result is a program that does the exact same thing as the original, but because it doesn't copy the original expression, the code, it typically doesn't infringe the copyright.
That's an incredible loophole. It seems then that even if you do have a copyright, you need to be strategic about enforcing it. A lot of creators I know operate under the assumption that since copyright protection is technically automatic the moment they create something, they don't need to do anything else. But you warn that this is a very costly mistake. Why is timely registration so important? It's a critical and often overlooked step. While it's true that a copyright exists the moment an idea is fixed in a tangible medium, your ability to actually enforce that right in court is severely limited without registration. Specifically, if you fail to register your copyright before an infringement begins, you generally lose the right to claim two of the most powerful remedies available: statutory damages, which are preset damages you can get without having to prove actual financial harm, and the recovery of your attorney's fees. These can be game changers in a legal dispute. The key takeaway is simple: register your work early. Waiting until you have a problem is almost always too late. That's excellent advice. Michael, this brings us to what I think might be the most counterintuitive and therefore most important section of your book for many business owners. It's about the very basic assumption that if you pay someone to create something for you, a logo, a piece of software, an article, that you automatically own it. You say this is not just wrong, but dangerously wrong. It's perhaps the single biggest pitfall I see entrepreneurs fall into. Our common sense tells us, I paid for it, therefore it's mine. But the default rules under the law are often the complete opposite. The book makes it very clear. Just because you pay for the work does not mean you own the underlying intellectual property. In many cases, without a written agreement that explicitly transfers or assigns ownership, the rights remain with the creator. The person who paid for the work may only end up with a limited license to use it, which can be a disaster for a business that needs to control its core assets. So, could you break down how those default rules differ for an independent contractor versus a full-time employee, because that distinction seems to be at the heart of the issue? Absolutely. The rules are quite different. For an independent contractor, the default rule is straightforward. The contractor who creates the work owns the intellectual property, unless there's a written agreement that says otherwise. For an employee, it's a bit more complex. Under a legal doctrine called work for hire, the employer generally owns the copyright for work an employee creates within the scope of their employment. But, and this is a very big but, that doctrine doesn't automatically cover inventions and the associated patent rights. The only way for a company to be absolutely certain it owns all the intellectual property created for it is to have clear, written agreements with everyone, both employees and contractors, that explicitly assign all IP rights to the company.
It all comes down to having it in writing. So Michael, given all these complexities we've discussed, the different tools, the timing issues, the ownership pitfalls, if you could recommend one single strategic action for a company or an entrepreneur to take, what would it be? Without a doubt, it would be to conduct a periodic intellectual property audit. This isn't a one-time thing. It means regularly taking stock of your assets. Inventory your patents, trademarks, copyrights, and trade secrets. Critically, review all of your employee and contractor agreements to make sure that chain of ownership is clear and unbroken. You also need to check for potential risks of infringing on others' rights, and, just as importantly, implement clear procedures to identify and protect the new ideas that are constantly being generated within the business. It's all about being proactive rather than reactive.
Michael, thank you for walking us through protecting your number one asset. This conversation gives our listeners a clearer understanding of how to think about and protect their ideas. The final question you leave in the book really sticks with me. Is your number one asset protected, or is it an unprotected liability waiting to be taken? Thank you, Sonny. I hope this discussion helps people recognize the value of their ideas and take steps to protect them thoughtfully. This has been Sonny's Mindset Lab. Thank you for listening, and we'll see you in the next episode.